Hello and welcome to Triage, timely conversations for healthcare professionals, a podcast created and produced by K&L Gates. Each episode is designed to highlight important developments in health law and analyze the impact on our clients and friends of the firm. We hope you enjoy this podcast.
Welcome to another episode of Triage. My name is Gabe Scott, and I'm a healthcare partner in K&L Gates Healthcare and FDA practice. Today, we're going to be discussing a significant update to the Federal Independent Dispute Resolution, or IDR, process under the No Surprises Act. So on May 28th, 2026, Departments of Health and Human Services, Labor, and Treasury, together with the Office of Personnel Management, issued a final rule making a number of operational changes to the federal IDR process. I'm joined by two of my colleagues from K&L Gates Healthcare Practice Group. Kevin Alonso is a partner in our Nashville office, and Cindy Ortega Ramos is an associate in our Chicago office.
Thanks for having us.
Great. So before we dive into the specific changes here, let's start with some basics. Cindy, first off, what is the federal IDR process, and why did the agencies feel the need to issue this rule?
Yeah, so thank you so much for having us, Gabe. And the federal IDR process is the mechanism established under the No Surprises Act to resolve certain payment disputes between payers and out-of-network providers. And since its implementation in 2022, out-of-network providers have submitted hundreds of thousands of claims under the current baseball-style arbitration process, which is significantly higher than the agencies originally anticipated. So as with any new process, not everything has gone smoothly. Over the last several years, the agencies have had to contend not only with a number of administrative burdens and operational challenges, but also with litigation. So this final rule is largely aimed at improving how the system functions rather than changing the substantive standards used to resolve payment disputes.
Got it. Thanks, Cindy. So of the changes that were made, what are some of the most significant ones?
So some of the most notable changes relate to improving communication between providers and payers. So now payers will be required to communicate information to out-of-network providers using specific claim adjustment reason codes and remittance advice remark codes, which is intended to help identify whether a claim is or is not subject to the federal IDR process. That requirement, although effective on August 3rd, 2026, does not become operational immediately. The agencies intend to issue future guidance implementing those provisions. And payers will also be required to submit additional information about the payer with their payment denials, as historically providers have sometimes found it difficult to identify the correct payer contact information in order to initiate the open negotiation process as well.
Thanks, Cindy. And one more interesting change in relation to that last point that's worth mentioning is that in the future, the agencies actually plan to have an IDR registry. Payers will have to register and receive a registration number and include that registration number with their payment denials. That should make it a lot easier for providers to initiate open negotiation and cut down on disputes being initiated against the wrong party. This is a work in progress, however. The IDR registry requirements won't go into effect until the agencies provide further guidance.
Thanks, Kevin. So, what about the sort of open negotiation process itself? As I understand it, providers can really initiate the open negotiation process, and then they may never actually receive a response from the payer.
Yeah, that's right. The 30 business day open negotiation period is an opportunity to settle things before getting too deep into the federal IDR process, and the agencies really want to encourage actual negotiations. In light of that, the final rule actually requires the non-initiating party, which is often the payer, to issue a response by the 15th business day of the open negotiation period.
Right. So it's really putting an onus on the payers to provide some sort of response and acknowledge that the process has begun. Cindy, there are obviously a lot of changes in this final rule, more than we have time to discuss here. But what are sort of two or three other notable changes that you think folks should care about?
Yeah, so I think there's maybe three changes that are definitely worth mentioning. The first one would be that existing regulations do not set a time frame for the certified IDR entities to make eligibility determinations. The final rule will require them to make eligibility determinations within 5 business days of their selection. So I think that's important. The second one would be that the agencies are making the federal IDR process more accessible by reducing the administrative fee from $115 to $15. And that was effective as of June 11, 2026. And I think lastly, the third one would be that batching will be limited to 50 items and services in a single dispute to help certified IDR entities more easily make timely eligibility and payment determinations. The definition of a batch dispute applies to disputes with open negotiation periods beginning 90 days after the effective day of these final rules. So I think those would be my key three changes to highlight.
Kevin, what should stakeholders be doing now, given the final rule here, as folks, look to adjust their processes to accommodate the changes under the final rule? What should they care about?
Yeah, so stakeholders should start evaluating existing workflows now to identify where operational changes are needed in light of the rulemaking. I think the new claim adjustment reason codes and remittent advice remark codes will help providers identify eligible claims with greater speed and accuracy. So, incorporating these new codes into existing workflows will be pretty important. Furthermore, if the $115 administrative fee previously dissuaded providers from the IDR process for low dollar claims, it might be worth a second look at this point, given that the fee is dropped to $15. Finally, given that many changes will require additional agency input, it's really important to continue monitoring the agency's publications for relevant guidance over the coming months.
Very interesting. Kevin and Cindy, thanks to you both for joining us today. And thanks to our listeners for engaging with another episode of Triage. These IDR process changes could really meaningfully reshape the negotiation process and how claims are handled under the No Surprises Act. And so we will continue to monitor further developments on this issue. In the meantime, if you have questions about IDR issues or other healthcare regulatory matters, please contact Cindy or Kevin or your current K&L Gates attorney. In the meantime, we'll be back with another episode of Triage. Thanks again for listening.
Thanks again for listening to Triage, timely conversations for healthcare professionals. New episodes are available for download through Apple Podcasts, Google Podcasts, and Spotify. By subscribing to Triage, you will receive timely notifications for each new episode. Also, if you have any topics you would like to hear discussed on Triage, please don't hesitate to email triagesupport@klgates.com. We would love to hear from you.